Justice.
Very much, Mr. Speaker, and I'm very pleased to have the opportunity to rise today and to speak to the motions before us. And I'll focus my remarks primarily on the motion from the member from Saanich Gulf Islands that Bill C-45 be amended by deleting Clause 9 in its entirety. Mr. Speaker, I'd like to first begin by acknowledging and thanking the member from Saanich Gulf Islands for her very thoughtful contribution to this ongoing debate and to this important issue. I think she has made a very significant contribution, and I value very much her opinion and her advice. I'd also like to commence by commending the work of our Standing Committee on Health for its study of Bill C-45 for all of its members, an act respecting cannabis to amend the Controlled Drugs and Substances Act, the Criminal Code, and other acts. The Health Committee returned to Ottawa in advance of the commencement of our fall session of Parliament, and they worked extensively throughout the month of September, hearing from many learned witnesses who provided their perspectives on a wide range of issues, from law enforcement to public health. Mr. Speaker, I would remind all of the honourable members present that Bill C-45 would provide a legislative framework for the legal and regulated access to cannabis when it is provided from authorized sources. And beyond that, Mr. Speaker, cannabis will be subject to certain prohibitions. With this in mind, I would like to point out a number of the important features of this bill that relate to the criminal law. The architecture of this legislation is such that cannabis remains a controlled substance. It cannot be accessed legally by youth, and it can only be accessed legally by adults by way of an authorized source. Division 1 of Part 1 of Bill C-45 shows that many of the offences that currently apply to cannabis under the Controlled Drugs and Substances Act will continue to exist under the proposed Cannabis Act. And this is very much in keeping with the final report of the Task Force on Cannabis Legalization and Regulation, which recommended to the government that criminal offences should be maintained for illicit production, trafficking, possession for the purpose of trafficking, possession for the purpose of export, and importing and exporting cannabis. Mr. Speaker, Clause 9, the proposed distribution clause, is also consistent with the Task Force's recommendations that our government seek to limit criminal prosecution for the less serious offences and to create exclusions for social sharing. Indeed, the proposed clause allows adults to share cannabis privately and to share up to 30 grams of cannabis in a public place, and it exempts young persons from criminal liability for sharing very small amounts up to 5 grams of cannabis. It's important to recognize, Mr. Speaker, of course, that every province and territory will also enact provincial legislation which will enable those jurisdictions to enforce an absolute prohibition for the possession, purchase, and consumption of cannabis by a person under the age of majority in those jurisdictions. But the enforcement of that law will result in a provincial offences ticket, Mr. Speaker, and not a criminal record for that child, thereby eliminating one of the significant harms that the Task Force and Canadians have recognized can be occasioned upon our young people as a result of the enforcement of the current law. I will discuss momentarily how the penalties proposed in Bill C-45 are already less stringent than the current penalties for cannabis offences under the Controlled Drugs and Substances Act. But before I do that, Mr. Speaker, I would like to review how Clause 9 is designed to operate. Clause 9 of Bill C-45 provides for the distribution offence. The term distribute, as defined in Clause 2 of the bill, includes administering, giving, transferring, transporting, sending, delivering, providing, or otherwise making available in any manner, whether directly or indirectly, and offering to distribute. Subclause 9.1 would set out prohibitions respecting the distribution of cannabis. Unless authorized under the Act, and for instance under a license or permit, the legislation would prohibit an adult, 18 years of age or older, from distributing more than 30 grams of any dried cannabis or its equivalent to another adult, any amount of cannabis to an individual who is under 18 years of age, any cannabis to an organization, or any cannabis that they know to be illicit cannabis. The proposed Clause 9 would also prohibit a young person from distributing more than 5 grams of any dried cannabis or its equivalent to another person, or for distributing cannabis to an organization. And finally, Mr. Speaker, Subclause 9.1 includes prohibitions related to the distribution of plants, as well as the distribution by organizations. Subclause 9.2 would prohibit the possession of cannabis for the purpose of distributing it, contrary to any of the prohibitions described above, and again, unless such possession is authorized under this Act. The penalties for adults who would commit an offence under Clause 9 would range from a ticket up to a maximum of 14 years imprisonment, depending entirely on the circumstances. And young persons who offend would be subject to a youth sentence under the Youth Criminal Justice Act. Mr. Speaker, the distribution provisions, along with other offence provisions in the proposed Cannabis Act, represent a marked departure for how cannabis is currently dealt with under the Controlled Drugs and Substances Act, whereas most cannabis-related offences under the CDSA are straight indictable offences, including the offence of trafficking, which includes most of the activities contained in the new definition of distribute under the Cannabis Act, and are punishable by up to life imprisonment. The criminal offences proposed in Bill C-45 are all what are commonly referred to as hybrid offences, which means that they can be prosecuted by way of an indictment or as a summary conviction offence. And in most cases under the proposed legislation, the maximum penalties when prosecuted by indictment would be up to 14 years imprisonment and up to 6 months imprisonment for prosecution on summary conviction. Mr. Speaker, it's very helpful, I think, for the members to understand that the maximum penalty, up to 14 years, is not for those circumstances that have been previously described of some young person passing a joint to another person who they mistakenly believe to be of age but might be under the age of 18. It is for those offenders and for those offences which are deemed to be the worst case. And so the worst offence would be a distribution to a very, very young child. And the worst offender would be a repeat offender, someone who has done this many, many times. And so the maximum penalty in our criminal justice system is deemed to be appropriate for those individuals who are the worst offenders and for those offences which are being deemed to be the worst. And in the overwhelming majority of circumstances, and certainly in the one described earlier by the honourable member from Saanich Gulf Islands, those would be dealt with in a more appropriate and proportional way by the police, by the prosecutors, and by the criminal justice system. I would also point out that the Cannabis Act proposes, as an alternative to the summary conviction and indictable procedures contained in the Criminal Code, a ticketing scheme for minor violations in certain criminal offences, including some of the distribution offences. And Mr. Speaker, this is entirely consistent with what law enforcement asked us in 2013 by their resolution at the CACP convention seeking such a ticketing scheme. During clause-by-clause consideration of Bill C-45, Clause 9 was the subject of 7 motions to amend, none of which were carried. Several of these Clause 9 motions sought to lower the penalties proposed for the distribution offences. One of these motions sought to remove the defence of mistake of fact, where the mistake of fact is as to age. And these defences are necessary. They ensure that an accused who wants to raise the defence of mistake of fact as to age must show that he took reasonable steps to ascertain the age of the young person, and by removing these defences, it would be contrary to the bill's purpose of protecting the health of young persons by restricting their access to cannabis. Mr. Speaker, the present motion from the member from Saanich Gulf Islands proposes simply to remove all of these prohibitions and accompanying penalties, and if passed would serve to defeat many of the key objectives of Bill C-45, which is to deter the illicit activities in relation to cannabis through appropriate sanctions and enforcement measures, to protect the health of young persons by restricting their access to cannabis, and if by removing the offence of distribution, the amendment would allow for the unlimited distribution of cannabis between adults, and perhaps more concerning, Mr. Speaker, would allow adults to distribute cannabis to young persons under the age of 18. I urge all honourable members to oppose this amendment. It is contrary to the purposes of Bill C-45. It would create a means whereby children and young persons could legally access cannabis from adults. And, Mr. Speaker, it would result in what could only be described as a free-for-all in relation to cannabis in Canada. That is not the intent of Bill C-45, and it does not accord with our government's intentions. Thank you, Mr. Speaker.
Questions and comments? The honourable member for Sarnia-Lambton.
Well, thank you, Mr. Speaker, and I'd like to thank the Parliamentary Secretary for his speech. I want to ask a question with regards to the possession amount. So we know that in this bill, 12 to 17-year-olds are allowed to possess up to 5 grams. And we know that adults over 18 are allowed to possess up to 30 grams. And we know that within a single dwelling, so if you were a single person living in a house, you can grow 4 plants that could be of any size because there's no limit to that now. And we heard testimony at committee that, you know, even plants, 4 of them 100 meters high, could grow up to 600 grams. So you could conceivably have quite a number of grams. And so if you are only allowed to possess 30, or if you're 12 to 17, only allowed to possess 5, and you're in your house, you actually possess way more than that, and so I'm not sure how that can be reconciled. And I also wondered why the member ignored the input of the police who testified at committee that they opposed home grow. Thank you, Mr. Speaker.
The Honourable Parliamentary Secretary.
Mr. Speaker, let me address the very first thing the member said, because not only was it completely incorrect, but with great respect, I believe it's also a dangerous thing to say. And the law is very clear. Under the Cannabis Act, we are not creating a criminal offence for young people between the ages of 12 and 18 to possess cannabis. But we've also been crystal clear, Mr. Speaker, that a prohibition for the possession, purchase, and the consumption of cannabis will be enforceable through provincial legislation. We've worked very closely with our provincial territorial counterparts. We've met with their justice officials and with their first ministers, and there is a common agreement and understanding that the appropriate level of control to keep cannabis out of the hands of our kids is not to criminalize them, not to give them that criminal record that can have devastating effects on their futures and their outcomes, but rather, Mr. Speaker, to enforce that law through provincial regulation, exactly, by the way, as we do with alcohol. And I would simply remind the member opposite and all members of this House, in every province and territory in this country, there is a Liquor License Act which contains provisions to prohibit the purchase, possession, and consumption of alcohol for persons under the age of majority. That offence is enforceable through under the Provincial Offences Act and does not result in a criminal record. That's the appropriate level of governance to enforce that prohibition. And, Mr. Speaker, I'm very concerned when this rather misleading statement is made, I'm sure completely unintentionally by the member from Sarnia, but to leave the impression with young people that the law allows them, and the law is going to allow them to possess, is a dangerous proposition, Mr. Speaker. And I would remind all young people there are very serious health and social consequences for the use of cannabis, and the possession of that cannabis will be contrary to provincial regulation, and that will be enforced.
Questions and comments. The Honourable Member for Vancouver Kingsway.
Thank you. Well, the Honourable Parliamentary Secretary of Health just pointed out something I think that's very true, which is that criminal convictions, particularly for young people, but not only for young people, have, I think in his words, devastating effects on people's lives. Yet, notwithstanding that the Prime Minister has admitted to smoking marijuana while he was an elected official, notwithstanding that his brother did so and got through connections, family connections, was in charge, and notwithstanding the fact that the NDP has been calling on this government to instruct superior prosecutors under federal jurisdiction to not prosecute Canadians right now for simple possession, when there's a bill coming that's going to make that behaviour legal, this government has refused. So my question to the honourable member is, if criminal records are so devastating, why is he and his government so content to let 50,000 Canadians be charged in the last 12 months for simple cannabis possession that will have devastating effects? And why doesn't this bill have a single provision that deals with pardoning those people once this bill becomes law?
Honourable Parliamentary Secretary.
Thank the member from Vancouver Kingsway for his question, and also by his very strong contribution to the Health Committee and to the discussions around this issue and this debate. Mr. Speaker, I would point out in my earlier remarks, cannabis is a controlled substance, and with the passage of Bill C-45, it will remain a controlled substance. We are proposing to control it through strict regulation rather than the criminal law. But until we have lifted the criminal prohibition, and put in place a well-structured framework of strong regulation for the production, distribution, and the consumption of cannabis, until we replace that current prohibition, the law remains in effect, so that we will maintain control. Now, the member has suggested that we should also deal within this bill with issues of record suspension and pardons. And with great respect to the member opposite, there is other legislation. And I've heard him speak against omnibus bills, and I'm confident that he would want us to deal with the cannabis control regulations in this bill separately, and if he wanted us to turn to a different discussion on the legislation that controls license suspension and pardons, that's a discussion for a future date.
Resuming debate.